see fully.
Registration has just started, so
Good.
you can go.
Welcome, everybody. Thank you very much, Julia, for hosting this second awareness panel. And let's go straight to the issue we are dealing here. What we are dealing here is trying to sketch, first of all, the main issue we should be aware when doing data science research, and not only, by the way. And we are now focusing on two sub-issues, if you want, data protection and IP, so to raise the general level of awareness. Still, we need to lay the ground for a broader landscape, and that's basically the role of my first speech. When all of you guys are doing research with data, with big data, and working with them, definitely you are worried about IP and data protection because you begin to be sensitive to the various fines up to several millions that you can have by violating the GDPR. Yet, we should be aware on the good side that IPI constraints and GDPR constraints are put in a broader framework. You don't use only personal data. And a lot of data you are using actually are technically not EU data. First point to take on. Second point to take on is that the EU is building a much broader regulatory landscape whose main aim is here at the bottom of the blue circle. That is trying to establish a free flow of research data and a real integrated research data spaces. And this has to do with a number of initiatives that are trying to build across EU, for instance, a cloud mainframe, a cloud infrastructure for EU, where data can be shared, safely shared, according to the EU general principle. So let's have a look, a little bit of a closer look before going into the data protection and then IP. What is this framework about? And we listed here some documents that are somehow widening the scope of this regulatory landscape. And basically, the main point here is that for non-personal data and the shared data, especially public administration's data, those sharing activities, those sharing mainstreams do not interfere with personal data protection, meaning that as long as those data remain non-personal, meaning they cannot in any way lead to direct or indirect re-identification of data subjects, there is no application of data protection law. To the contrary, every time those data could be re-identified, then full GDPR steps in. This is important when dealing with the machine learning process, for instance, or big data sets, because according to the different level, and in SoBigData, it's very important for that, according to the additional information that can come in the picture, very, how do you say, non-personal data can easily lead to re-identification. So some safeguards can kick in. So to pick two extreme points, we are very aware that location data are clearly personal data. Meanwhile, other data from, let's say, intelligent sensors, the brakes in a car or in another mobility device, technically speaking, they are just sending information about the object, the thing. So in principle, they are not personal data. But once they can be linked or shared with other information that can lead to the owner of the car, to put it very, very simple, straightforward way, then they might trigger GDPR. Okay? Against this background, the larger picture is that we have, for researchers especially, a large and very broad set of information which are pushed to be shared even for commercial purposes. So the director of on public shareable information, on so-called open data and reuse from public administration, those information are open to be used for research, of course, up to the point and including for commercial purposes, with a non-exclusive right to use them. At the same time, and with reference to research, the EU recommendation, the European Commission, recommendation 790, it's pushing forward each member state to open and share scientific information. So the constraints are in a larger set, in a larger playing field, in which the aim, including the aim, as we shall see in a moment, of data protection is to foster a free flow of research data, a larger reuse of those information for public benefit, but even up to the point of private profit, if you want, for commercial purpose. All them together, this broad landscape, are contributing, so all these are contributing to a common EU data space. That's the goal. And that's where, basically, the research regimes for data protection kicks in. So this, to go a little bit deeper on the interplay between the market needs and innovation needs before we go to the GDPR, let me stress again that while the Directive 1024 on open data I mentioned, it's basically offering a non-exclusive reuse right of public data for commercial purposes, as long as GDPR is complied with. Okay. The regulation 1807 is basically aiming to take away the roadblocks to the free data flow. And there are two main ones, which are a huge concern, not only in Europe. I mean, the main issues all companies across the world are worried about is whether or not there will be some location data lock-in different countries. And think about it, one of the big concerns is India, where a lot of even machine learning activities and data training are relocated and delocated. And that's where some concerns are strongly, because the legislation onward that is under process there is envisaging very strong lock-in situations at the level of public security. At European level, basically from May 30, 2021, so we are very close, only for very clear, strong, and limited reasons of public security, member states can issue obligations for locating data internally of the member state. And those location constraints must be very strict and proportionate. And any other vendor lock-in practices, basically inability to share data among commercial institutions, should be basically wiped out with a pretty large right of portability, which mirrors the right of portability in GDPR. Okay. Now, I think I've said enough also on the pushing of member states to implement clear policies and action plans for exchanging scientific information. So let's go deeper on the data protection GDPR. So what do we want to stress here? The message is GDPR offers constraints, that's for sure. Its main task is to protect fundamental rights. That is a twofold objective, twofold goal. One is protecting fundamental rights, and especially at the fundamental rights of data protection. At the same time, it's to promote the free flow of personal information. I mean, the scope, the legal scope of the GDPR, it's serving these two apparently competing, but blended together, objectives and goals. If you start looking at it from this angle, it's rather clear that the implications for the research are, if you want, opposite than constraints. It's just setting the parameters to expand the reach of research. That's why we have named basically two main key to read the GDPR in the proper way. So as long as we follow and play with the rules of the GDPR, we can have both results that can profit of the proceduralization and of the enabling capacity of the data protection legal framework of the GDPR. So first thing, since the data protection rules, the GDPR, it's offering clear procedures and patterns to fulfill the general principles of fairness, transparency, and especially accountability. We have a clear pattern to follow in order to enable things. So the key message here is GDPR does not prevent you to do research. The GDPR only tells you how to do it in a way that enables you to do the research, to share without infringing other people's rights, namely data protection rights and other fundamental rights. And this proceduralization goes through different avenues. On the one hand, the general principles stated in Article 5. On the other hand, the auditing powers, certification enabling, and so on and so forth from the data protection authorities. Don't forget that in the GDPR, there is a very huge novelty. Before, the legal framework basically requested, in order to get, when there was some room for the data protection authorities, to go one by one. Now we can move towards one authority, and with their mechanism, once we get approval for what we need from one authority, that expands basically automatically for what concerns us to across all over the European Union. And the third avenue in which you have some clear procedures, it's exercise of individual rights. So as long as we have a clear framework, proper template, and policies in place, clearly we can enable those rights, and those rights at the same time can help us to keep within the limits. We are basically able to turn data subjects from enemies that are trying to avoid our data processing in friends that helps, by their exercise of rights, help us to keep in the right lines of the compliance. So from procedure to enabling them. So what is those proceduralizing? It's also enabling us to expand the reach. That would be dealt with more in detail by Julia Snyder in here. So those proceduralization, along with what I'm going to say, they are enabling data controllers to do more research activities. How? First of all, from some derogation that are enjoyed in doing research. But again, do not forget, derogation is not just a blank license to do whatever we want. A derogation is not changing the meaning of things. So, for instance, we need to understand that there is a huge difference, but that will be dealt by Caterina and Julia Pideora more in detail. Doesn't mean that if you can access something freely on the web, that's free to use, or it's freed by any GDPR constraints. But let's have a 2 minutes closer look on these issues before I leave the floor to someone else. So basically, the framework for research, it's offering some derogations. For instance, and it's very interesting, and it's related to what I said in the broader landscape of regulatory landscape. For research, we have some, let's call them presumptions that basically further research is presumptively in line with the previous purposes of data collection. This doesn't mean that we have a blanket license to do further research. We still have to run the analysis whether or not, for instance, in using a data set collected for one purpose, once we put it in the research infrastructure of SoBigData++ for further use, we need to still run the analysis whether or not some constraints, for instance, safeguards, should be put in there. That can be organizational or technical ones. Organizational, for instance, limiting the license, or technical ones, for instance, scrambling the data so that it's more difficult to identify, okay? And at the storage limitation, the key concept there is that we don't want to throw the baby with water when we finish research. Again, the fact that we can keep longer, potentially ad libitum, if you want, data for research, doesn't mean that we don't have to put appropriate safeguards to protect them for a number of reasons, okay? So basically that goes, I've already spoken a little bit about the compatibility test. We cannot go deeper in that, but probably we'll have an awareness panel probably related to the compatibility test for further use, because that's really changing basically domain by domain, whether or not you are working, for instance, with health data, or depending on the kind of fundamental rights which can come into the play, or once again, as an example, whether or not it can trigger a discriminatory pattern that can really harm the fundamental rights. So going beyond just data protection, all right? And there is a third line of enabling derogation, which is related to the right to information, which are simplified.